3-4 slides available, we'll do that. I could have applied it.
26 तारीख स्टार्ट आला 11 तारीख पर्यंत मोर गोटे क्लास আছে না 17 18 যেটা মোর নাই এটা পার্টিতে এনে কর্পোরেটটা আছে না কর্পোরেট মোর ক্লাস আছে ক্লাস করিও
We have completed the Narayan Murthy committee. What were the recommendations for Narayan Murthy committee, which is related, which was formed by SEBI as a second committee formed by SEBI, and it gave certain recommendations. Naresh Chandra committee was set up by Ministry of Corporate Affairs for, again, formulations of guidelines for corporate governance. This is the, somebody's mic, I don't know, please switch off wherever. When there is no need, please switch off all your mics so that unnecessary noises are eliminated. This is a request. So, we will now read about Naresh Chandra committee recommendations. So, Naresh Chandra committee also was based on after KM Birla committee, and they try to carry forward whatever has been said in KM Birla committee. And this committee emphasized between the relations between the auditor and the clients. Who are the clients? In this case, the client is the company. So whatever the company auditor who has been appointed by the board and the company, the relation has to be was defined, or more explicitly told that this is the way the auditor should work. Then increase role of independent directors, CEO and CFO to certify reports, set up quality review boards for ICWAI, ICAI, ICSI, etc. What is ICWAI, ICAI, and ICSI? Any idea?
ICAI, Indian Institute of Chartered Accountant of India.
Yeah. The other one is company secretary, and it is cost accounting. CWAI is cost accounting. So Naresh Chandra committee advised that the standards and the procedures given by these societies should also be reviewed to make it up to date. The committee recommended for clear description in plain English. For actually, if you go through these laws and recommendations and committee now, you will find that they have gone into minute detail of everything. Now, see, a committee is recommending that you must write plain English. Why? Because every shareholder may not understand if you start writing in hi-fi English. So that is why they are saying that whatever you are giving in the report should be as simple as possible. Then, and what about that? You have to write pending lawsuits and product warranties. Wherever there is a risk involved, you have to clearly mention what is the risk. And legal issues are, all of us know that, the legal languages are very difficult to understand for a common people. So that is why it is said whenever you are, because risks have to be highlighted in the report, and it should be done in plain English. Perception of risk be accompanied by the auditor's clearly worded comments on the management's view. Now the management is supposed to give a mitigation measure.
Sir, voice is not coming.
You are unable to hear me?
Hello. Yes, sir.
No, sir, we are able. I think there should problem result.
So in the report, the management of or the committee, the management has to give its view on each of the risks. And this Naresh Chandra committee made it mandatory that the auditor also should give his view on what the management is saying, whether he is agreeing with the risk, the mitigation measures or the risk assessment of management, or he has something else. So all that has to be given. Significant accounting policies and notes on accounts as well as in auditor's report where necessary. So the auditor also has to give clarifying notes wherever necessary in the annual reports. Certification by CEO, either the executive chairman or the managing director, whosoever is the CEO, or even if there can be another independent CEO if there are no executive chairman or managing director, or even if they are there can be a CEO and CFO, whole-time finance director, or other person discharging this function. So both these people also have to certify the balance sheet and profit and loss account along with the auditor and directors. The certification is for the following: reviewed the balance sheet and profit and loss account and all its schedules and notes on account, the cash flow statement and the director report. They will say that whatever is written is true to the best of my knowledge. They cannot just say after some time when there is a case or there is an issue, they cannot just say, I do not know or I have not seen or something like that. So that is why certification was made mandatory. Do not contain any material untrue statement or omit any material fact, nor do they contain statement that might be misleading. So this is the certification. Present a true and fair view of the company and are in compliance with the existing accounting standards, applicable laws and regulations. So these three, a certification by CEO and CFO means that the company's report is complying to all these three requirements. So tomorrow they can be held responsible. Responsible for establishing, maintaining, and have evaluated the effectiveness of internal control system. So they have to also certify this, that the internal control system is working and they have been evaluating, monitoring, taking corrective action wherever required. Disclose the deficiency in the design or operation of internal controls, if any. Disclose the instances of significant fraud, if any. And independent director, section 4. So independent director, how independent they are, whatever they have done, all that has to be given, that these independent directors have operated well and they have done this. Actually, in the corporate governance model, now there is a review of the performance of directors. Then independence of audit committee, that also is to be certified. Exempt non-executive and independent directors from criminal and civil liabilities under certain circumstances. So the committee gave the exemption or recommended that the non-executives and independent directors should not be held responsible for criminal and civil liabilities under certain circumstances, whereas the executive and the regular director will be held responsible. SEBI need to specifically spell out such exemption. So this was left to SEBI to specify where the independent and non-executive directors can be exempted. Jahara mic on, please switch off. Somebody's. Again, somebody is traveling or something. Unnecessary.
Suman Saurabh.
Whosoever he is, please switch off your mic. Indicate in the notes on accounts whether or not there were significant changes in internal control or accounting policies during the year. Independent directors should periodically review legal compliance report. Defense should not be permitted on ground of unawareness of the responsibilities. Harmonization of clause 49 of listing agreement and the provisions of Companies Act 1956. Actually, the last part, which was recommended by Naresh Chandra Committee, has been taken care by the new Act of 2013. So with this, we have finished module 2. In module 2, we have read about the various corporate governance structures in various countries, and specifically we have read about how Indian corporate governance structure has evolved. What are the major points? So with this, we have concluded module 2. Now we'll immediately go to module 3, because we people are running out of time. And module 3 is about agents and institutions in corporate governance. Who are the people who are responsible or responsible for implementation of the corporate governance practices in the company, and what are the institutions? These are all very specific to India. Okay, we are talking only to Indian corporate governance. We are not now referring to any foreign context, even though there are many similarities between the countries, as we have read in the last module. And this course or this module covers agents and institutions in corporate governance, rights and privileges of shareholder, investors' problem and protection. What are the mechanisms given in Indian law and all, corporate governance and other stakeholders, board of directors and auditors, banks and corporate governance. So these are the points. So we'll take one by one. Now, agents in corporate governance. Do you know what is the definition of an agent? I have written already, but if you have some idea, you can also share. Agent is someone who represents another person on or his or her behalf, and he or she has the rights to take decision on behalf of another person. I think many of you must have heard about power of attorney.
Yes, sir. POA, power of attorney.
And power
No,
of
sir.
attorney.
No, sir.
Power of attorney, you have heard?
Yes,
No,
sir.
sir.
If the power of attorney is someone is giving rights to another person on his behalf or her behalf.
It is generally related to property and land and all that. But nowadays the rules for land also is very stringent. But power of attorney means you are authorizing through a legal document someone to act on your behalf. It means you are appointing him as an agent. Though the word agent doesn't sound well always, but in corporate governance, I think if you have read, if you remember anything of the model of US, there is agency cost. Means the persons who are operating or taking decision on day-to-day basis for running the company are the agents of the board or the shareholders. So an agent, the agent, the responsibility of implementing corporate governance in a company lies on the agent in a way. So we will try to understand who are the agents. So who is an agent? A person who acts on behalf of another person, a person who manages business, financial or contractual matters for an actor, performer, etc., whatever. Then your legal representative can be when you are signing an wakalatnama, you are letting the advocate work as an agent for you, even though he is representing you, but he is like, whatever he says in the court, whatever you have said is one, but whatever he says in the court is on your behalf. So he is an agent. That way you are authorizing him to take up the case for you. A person who works secretly to obtain information for a government, this is also another definition. But with respect to corporate governance, who are the agents? Who can be the agents? The directors can be the agent, the auditors can be the agent, and the shareholders can be agent. Now, how shareholders can be agent? Because shareholders are also responsible for ensuring corporate governance in the company. Now, the company as an entity doesn't exist. It exists through all these people. So these are the people through which the company can really implement corporate governance. So that is why this topic or these people are designated as agents.
Sir, employee also can be agent for corporate agent.
Who? Who can be an agent? Okay. So next is we'll read about these three: directors, auditors, and shareholders. Who directors in a company has the following role: fiduciary role. It is a role which is mainly relating to money or financial matters. He acts as a trustee of the company. Then common law duties. There are certain duties which are as per common applicable laws. Specific duties prescribed under Companies Act. Additional duties in case of a listed company and other statutory duties. So we'll read one by one. Act as a trustee. Fiduciary duties are good faith and bona fide acts. The director must act honestly without negligence and in good faith in the bona fide best interest of the company. So that is one of the things which is the role of a director. He can't be a director and work against the interest of the company. Proper use of powers. Director must exercise their powers for purpose for which they are conferred on them. Power not to be misused for selfish interest. Unfettered discretion. Always they will apply their discretion while taking a decision. They cannot validly contract or act with one another or with third parties as to how they shall vote at board meetings or otherwise conduct themselves in future. Means there cannot be a groupism in the board of directors. The few board of directors, they can, once they have exercised their discretion, they find that the decision of the other members is not correct, they can vote in unison. But they should not just be influenced by another director without exercising his or her own discretion. So they have to be very discreet in their approach for any items which is placed before the board for decision. They have to exercise their intelligence, they have to exercise their intellect to arrive at the various decisions. Then lack of conflicting interest. Conflict of interest is another big area where fraud can take place. So director should not have conflict of interest. Means they should not be involved in activities where there is a possibility that the company may lose and they personally may gain. So that is where, or suppose he is a director in two companies, he cannot do harm to one company and make benefit to another company by harming another. No, that is not allowed. So directors have to make continuous disclosure of their interest in various transactions of and with the company. Directors cannot use without the consent of the company's properties, opportunities, or information for their own profit. Directors have a duty not to compete with the company. So this is another responsibility of a board of directors. Then next is common law duties. A director is required to discharge certain common law duties towards the company, which broadly consists of the following: duty to exercise reasonable skill and care. This rule consists of two elements: an objective duty of care and a subjective duty to exercise skill. So care means duty of care means he will go through everything properly, carefully to understand, and wherever needed, he may seek clarifications and all that. And next is, if he has experience, if he has knowledge, if he has skill, he also has to exercise that skill in deciding about or helping the company to decide on a matter. Duty to act within the powers of the company. Whatever the company has decided, memorandum of articles, which they set out the work the company will do, the director should work within that. Means a company which is engaged in manufacturing should not immediately, cannot get into another way of business of trading. Generally, I don't know if you are aware, but whenever you register with any, suppose you have a small company and you want to work with any big company. Now, in many of the companies, while you registered as a vendor for supply or for some other work, they will always ask for a certified copy of the memorandum and articles of association, memorandum of association. Now, in memorandum of association, the objective for which your company is formed has to be clearly mentioned. concerned. And if the objective and what you are proposing to work are not same, you cannot be registered. So similarly, for a director, the job of the company has to be within the what has been prescribed or agreed in the memorandum and article of association. Actually, these are the two documents which are registered with registrar of companies when the company is formed. It can be amended from time to time, but that will decide the power of the directors and also the objective for which the company is working.
Yes, sir, that will be the changes are the shareholder approval by shareholders, not by directors.
I could not understand what you are saying.
Sir, actually, you are talking about MA and AV can be amended by shareholders. I mean, approval by shareholders.
I didn't say who can amend the MOA or AOA. I am only saying, as per this document, the company, the director should work within the powers given in that document, and these documents can be amended. Who can amend and how can we amend? That's a separate rule. I'm not going into that. What I am trying to say is, if MOA or AOA has been made, it is not that the same cannot be changed anytime. You can add objectives, you can add work, you can do certain changes. That is all possible.
Sir, I'm just trying to say that. Yes.
Duty to exercise independent judgment. Directors should not take decisions at the discretion of direction of others. They should independently judge on every item and give an opinion. They should not be influenced by others' decisions. Duty of supervision. The directors have a duty to exercise supervision over the officers of the company to whom they delegate powers. This supervision, you may ask how it will be done. Actually, when the board of directors meets, there are review of everything, many of the things, of how the company is working. When there is a review of results, there is a review of various activities the company has done during that quarter and all that. So during that time, the directors can question, raise question, get reply, and try to supervise things. Duty of confidentiality. Directors are duty bound not to disclose any of the important information relating to the company's business and operations. Other specific duties as per Companies Act: administration and compliance, filing returns with with registrar of companies. That is the duty of the director. The ROC can, registrar of companies, can punish or bar directors from doing day-to-day activities if they fail to do certain returns which are to be filed with them. Directors must file a return of allotment of shares within 30 days with the registrar. This 30 days is how much share they have or allotment of the shares. So they have to tell, or if suppose somebody is investing and then you are allotting share to that person, that also has to be registered with informed to the registrar of companies. Convening shareholders meeting. Director must convene the different kinds of shareholder meeting provided for in the Companies Act. This is the role of a director, to convene a meeting. A statutory meeting should be convened after 1 month, but within 6 months from the date on which a public company is entitled to commence its business. So from commencement of business, it should be 1 month or maximum 6 months from the date. The first AGM should be convened within 18 months from the date of incorporation, because there is a 6 months time given for the first meeting. So you are given another 1 year. So 18 months is the outer date. An extraordinary general meeting must be convened by the directors on a requisition by members holding at least 10% of the paid up capital of the company. So paid up capital, if certain number of shareholders who are amounting to around 10% of the paid up capital, they give a notice to the board that we want to have an extraordinary general meeting, then the directors are bound to accept that. Approval of company's document. Directors must approve the balance sheet and profit and loss account. Audit requirements. In cases of winding up or liquidation, the director must ensure that the books of accounts of the company are completed and audited up to the date of winding up, or the order issued by the company code. Or even if they suo motu close a company, then they have to ensure that the books of accounts have been done properly. Actually, if you want to close a company, there is a provision in ROC that you have to give an affidavit. Even if suppose you have said that everything is closed, there is no liability, nobody's payment is due or whatever. But in spite of that, the ROC will take an affidavit. Suppose in future some cases arise, then the director will be personally responsible to fulfill that requirement if found proper. Additional duties in case of listed companies. Which is a listed company? Or what is different in a listed company and not listed company?
Listed in a share market, exchange,
In
stock exchange.
Its share is traded freely in the stock exchange. Somebody can buy and sell the share of that company. So that is a listed company. And for listing in a share exchange, there is an agreement, LODR. The name is LODR agreement, and there are certain conditions which will make you qualify for listing. Otherwise, you will not be listed. Now, companies, when they make initial public offer, that is the start of listing. So they raise money and then get listed. So first they have to prepare a prospectus, get approved from SEBI, and once the SEBI approves everything, then the IPO can be issued, and the day of there can be a day of listing when the shares will be allotted to the person who have invested or participated in the IPO. After that, those shares will remain, but a company can always recall, depending on the company's policy and all, company can delist itself from the stock exchange. Now, HDFC Bank and HDFC Housing Development Finance Corporation, after their merger, the HDFC is getting delisted from this stock exchange. HDFC Bank will remain listed because HDFC as a company is now no more existing. It is merging with HDFC Bank. Similarly, there are another thing is, I think ICICI Direct and ICICI Bank, they are also getting merged or something like that. I'm not very sure, but
No, sir. It is delisting. It is delisting ICICI Securities. Getting delisted, and the swap ratio, equity to swap ratio, the ICICI Bank shares will be allocated.
so this is possible as per law that you can some list and delist also. But there are certain duties of a listed company. What are the duties? Declaration of pecuniary relationship. Monetary relationship has to be declared between the non-executive directors vis-a-vis the company. Means how much money they are getting in lieu of their services, or if at all they are getting, whatever they are getting, whether compensation for services or as a consultant, or if they are also having some contract for some other work, all that has to be declared. Declaration of material contracts. In the prospect of a public offer, the details of the remuneration of a director within or more than 2 years before the date of prospectus should be declared. So this is about the initial public offer, the listing before the listing. So in the prospectus of IPO, the remuneration of directors within or more than 2 years before the date of prospectus should be declared. All that, how much amount has been paid before even listing, has to be given, because that will give an idea how much the directors are drawing from the company. The company also needs to disclose the details of every material contract not being in the ordinary course of business entered into more than 2 years before the date of prospectus. Material contract is like supply or any other work and all, wherever there is a money transaction. Last part of it is the other statutory duties. The duties under Foreign Exchange Management Act. This is one of the very strict act. Here, any violation of FEMA can lead you to arrest. There have been cases where directors have been put to jail for violation of FEMA Act, even though they personally were not involved in that transaction. To abide by the Foreign Exchange Management Act 1999 and its related rules regarding transaction between an Indian entity and a foreign entity. And this is a very stringent and very strong act where the directors can even be jailed or a criminal case can be filed against them. Duties under the Negotiable Instrument Act. Can you tell me what is a negotiable instrument? Are you aware, any one of you?
Bill of exchange.
Yes, sir. There will
Yes.
be a lot of list check, bill of exchange like that. Negotiable instrument.
I am only asking one. You can say one. There may be a lot, but check is the most common negotiable instrument which we generally use. Many of us use. So the bank checks and all that are the most common negotiable instrument. Means once you give a free, if you hand over a check to someone with his name or something with your signature and all that, that is equivalent to giving money to that fellow. So that is why we have to always be very careful in handling checks. So there are certain duties of directors under Negotiable Instrument Act. Under the Negotiable Instrument Act 1881, if a company issues and later dishonor a check, every person who at the time of such dishonor was in charge of overall control of the day-to-day business of the company, both under law and as a matter of fact, shall be deemed to be guilty of the offences and shall be liable to be proceeded against. Means anyone who both under law and as a matter of fact, means a direct board of directors which supervises the act of its finance person also, because that is as per law, it says that the director has to supervise. Now, if suppose a cashier issues a check and he can go to jail, but even the director also is liable to be punished. Depends on how the court decides or whosoever it decides. But that is the liability the director takes. Duties under Competition Act.
Sir, 1 minute, sir. Sir, if we are giving a check, issuing a check, then it is similar to issuing money to that party. Then how it is coming under a negotiable instrument?
Do you know why it is called negotiable instrument?
No, sir. No, sir. I have not.
Negotiable instrument is said that when you are signing a check, why you are signing a check? To give some certain amount of money to a person, why are you signing that check? Because that is what is due. There is a discussion, there is a work, there is a negotiation, there is a give and take into that. So and the negotiation is between the bank and the person. Means when the person goes to the bank with a signed check from your side, okay, then
Yes,
it is
sir.
represented. So that process is called negotiation. It is not the normal negotiation we are talking of. It is not like bargaining. The whole process is whenever you are presenting a check to the person who is paying, you are presenting a check which has been signed by the owner, or you are presenting a check to the bank on behalf of the owner in a way. Because if you see pay to dash or bearer, it is written like that. So you are giving an instruction
Yes,
to
sir.
the bank. You are giving an instruction to the bank for payment. That process of payment, settlement of payment is called negotiation. That is why it is termed negotiable act instrument. Combination, the competition, and there are also duties under the Competition Act. Do you know about Competition Commission of India? Are you aware? CCI.
Yes, sir. Yes, sir.
It ensures that monopolies and restrictive trade practices are not allowed. There is free and open market for everything. So actually for merger and acquisition, CCI clearance is one of the most required clearance. Suppose a CCI doesn't give you clearance, you cannot merge any company with yourself or whatever. Okay. So there are rules under the Competition Act also. Imposes a certain limits to be examined and adhered to by directors and requires that the merger or amalgamation or acquisition does not amount to a resultant enterprise leading to a simple combination. Simple combination means where you will be landing up in a position of monopoly. Actually, when we talk of simple English, no, this type of English also is not simple. It should simply say that the directors, whenever they are taking a decision for merger and acquisition, they have to ensure themselves, let the competition may reject or approve. But before that, it is the duty of the director to ensure that by this acquisition, they are not lending up, their main intention is not to become a monopolistic company, but you are not hampering the open market system. So when you are recommending certain things for merger and acquisition, as a director, you also take responsibility that you are not creating a monopolistic situation. So the Competition Act gives that duty to the director itself. Duty to file report with the commission. Directors must show that such a combination under Competition Act 2002 is not likely to cause an appreciable adverse effect on competition within the relevant market in India. In spite of this report or undertaking, the Competition Commission can still reject the proposal, because if they are not convinced with the director's report, they will not approve. But the Competition Commission makes it mandatory for the director for themselves to examine the case on merit before they submit the report to the commission. Duties under labor laws. We know that this is another major area. In legislation such as Employees Provident Fund and Miscellaneous Provision Act 1952 and the Payment of Gratuity Act 1972, the term employer with respect to any establishment in cases other than a factory means the person who or the authority which has the ultimate control over the affairs of the establishment. Why other than factory? In factory, the factory manager, he is looking after operations and all. He may not be involved in the HR and other policies. So that is why he is exempted. But otherwise, anyone who is in the management, top management, we can be held responsible for violation of PF and gratuity issues. Now we will see the role of an auditor as an agent. As per section 139, that is of the Companies Act, every company shall at the first AGM appoint an auditor. An individual or a firm appointment includes reappointment. So the AGM is required for reappointment also. And we will see there are also defined terms for each one. Now in India, who can be an auditor? Any idea? Or who can qualify to be an auditor? In India, it is only.
Sir, there is statutory auditor, वो ICIC से जो approval ले रखा है auditor वही हो सकते सर.
Actually, a certified chartered accountant can be an auditor in India.
Yes,
any firm can be an auditor. The auditor can be an individual or a firm, and any firm can be an auditor if one of the partner is a certified chartered accountant.
Yes,
but
sir.
without a chartered accountant, no firm or no person can be an auditor. If you have any other certificate, you cannot be appointed as an auditor. That is one mandatory rule in India. And what is the role of an auditor? It examines the accounting
books of account.
And the auditor, while examining the books of account, is also will look into whether the procedures, laid down procedures of transparency and all, whatever, and ensuring competition, etc., in procurement, in tendering and all that has been followed or not, whether proper approval has been taken or not. So they will not only check the accounts for errors on plus minus, that is another error, but they also go into procedural issues. Company cannot appoint an individual as an auditor for more than one term of 5 consecutive years, and an audit firm as an auditor for more than 2 terms of 5 consecutive years. So a single person as an auditor can work for 5 years. So every year he has to be reappointed, but for 5 consecutive years, he will be there. After that, he has to be changed. And if it is a firm, then the firm can remain for 10 years.
Yes, sir.
An auditor will not be eligible for reappointment from 5 years from the completion of its terms and after completing a 5 years term. Means, if suppose consecutively 5 years somebody works, then there will be a cooling off period of 5 years. After that only he can be appointed. Why this has been done? This has been done to avoid any collusion between the promoter and the auditor, to safeguard the shareholders' interest. If a partner who is in charge of an audit firm and also certifies the financial statement of the company retires from that said firm and joins another firm, such other firm shall also be ineligible to be appointed for a period of 5 years. So suppose a firm has completed another 10 years of auditing. The one of the partner who was signing the documents has now resigned from this firm and joined another firm. The other firms also become ineligible for next 5 years. This is again to avoid any cooperation between the promoter and the auditor. Now, who are the auditors in government companies? CAG is the main body who appoints auditors in government companies, PSUs and all. CAG audit is one of the main audit. The companies generally have internal auditors. They do day-to-day monitoring, but final audit is by the CAG. For all PSUs, CAG appoints a group. They come and examine. After that, CAG puts off a final report to the parliament, where all the public sectors are covered. Wherever there are discrepancies or issues, that is highlighted in that report and that is put up in the parliament.
Yes, sir.
CAG, then there is one in Orissa, in the state, Accountant General AG is the auditor for state PSUs. They also do similar activities as CAG, and for state PSUs, they put up the report in the assembly. Eligibility and qualification and disqualification of auditor. A person will be qualified to be appointed as an auditor for a company only if he is a chartered accountant. In case of a firm, only the partners who are chartered accountant can be an auditor. A person will be disqualified as an auditor on the following grounds. An officer or employee of the company, he cannot be an auditor. So a chartered accountant who is employed in the company on regular basis cannot be an auditor. A person whose relative is a director or is in the employment of the company as a director or key managerial personnel, then he also cannot be the auditor of that. A person who has been convicted by court of an offense involving fraud and a period of 10 years has not elapsed from the date of such conviction. So in that case also, he cannot be appointed as an auditor. Then what are the duties of the auditor? The auditor makes reports and examine every financial statement and give a report to the members of the company. The auditor's report will include whether he has sought and obtained all necessary information and explanation, whether proper books of account have been kept, whether company's balance sheet and profit and loss accounts are in agreement with the books of accounts and returns. As I have already said, there is the CAG is the auditor of government companies, and CAG, which the auditor must submit a report to CAG, which should include the action taken by him and the impact on accounts and financial statement of the company. The CAG of India India shall within 60 days of receipt of the report have the right to conduct a supplementary audit and comment upon or supplement such audit report. The CAG may cause test audit to be conducted for the accounts of such company. Actually, the principal auditor, there are regional offices of CAG also. There is, for Eastern region, there is an office in Calcutta who takes care of this. Now they submit to CAG. Now CAG can again ask question on the reports of the auditor, and as it is said, it can conduct a supplementary audit, it can do a test audit to confirm what has been seen is okay, because these are all to avoid any collusion between the company and the auditor. And the auditors are. I could not get you.
Sir, can you please let me know what CAG stands for?
Comptroller and Auditor General of India.
Thanks.
Then the auditors are liable for to pay damage. As per Section 245 of Companies Act again, the depository and members of the company also have right to claim damages or compensation from the auditor, including audit firm of the company, for any improper or misleading statement of particulars made in his audit report or for any fraudulent, unlawful or wrongful act of conduct. Means, if the auditor deliberately certifies something which is wrong, then the shareholders can take action against him and recover the amount. That is, there is a provision in the law, but whether to do that, you have to go to court, establish everything, and then get into that. Now, there may be like you are an auditor of a company, but the company have various branches. So, what is the role of the auditor? Where a company has a branch office, the accounts of that office shall be audited either by the auditor appointed for the company or by any other person qualified for appointment as an auditor of the company. The branch auditor shall prepare a report on the accounts of the branch examined by him and send it to the auditor of the company, who shall deal with it in his report in such manner as he considers necessary. So the final report of the company will also include the branch audit report. And the auditor, if he is not satisfied with the branch auditor, he can himself examine and do necessary corrections. Auditing standards are notified by central government and also in consultation with the Institute of Chartered Accountant of India. They are the one who always try to bring in more accountability and revise the standards, and government also may direct them to do so. The government may also notify that auditor's report shall include a statement on such matter as notified. So after the changes we have read in the recommendations of Kumar Mangalam Birla Committee, Narayana Murthy Committee, Naresh Chandra Committee, there are certain statements to be made, like simple English and all that, whatever they have said in financing terms also, that is applicable to the auditors, because that is as per SEBI is a semi-autonomous body, is a government body, and government MCA, Ministry of Corporate Affairs, can direct. Then fraud reporting. If an auditor of a company finds that an offense involving fraud is or has been committed against the company by officers or employees, he shall immediately report the matter to central government. He can do that. He can report to board, he can do to the central government. Winding up. As per section 305, at the time of voluntary winding up of a company, it is a mandatory requirement that auditors should attach the company of the audits of the company prepared by him. So finally also, when you are, as we have seen in the role of the directors, in where the company is winding up, the auditor also has to make the final report. It is also his duty. Now, what is examined by the auditor? I think most of you, any one of you have faced any auditor's examination while in your office?
Sir, I'm an auditor. So I have been.
I'm asking people who have faced auditors, because you know,
no, sir.
you are an auditor, you know what you ask, but I'm saying the experience. I want to know the experience of people who have faced audits.
Yes, sir. This is
Yes, sir, we have faced.
Because I am looking at audit part India as usual subsidiary part.
So you have faced questions from audits?
Yes, sir. I mean, as I said, after Indian auditor as usual subsidiary auditors. Both IFS, because recently our audit is going on. That's telling you.
No, but every year there is audit. So
yes,
you
sir.
know the questions of auditors are very difficult sometimes. You know, and being a technical person, I have seen, and you know, they can ask anything and everything, and it is very difficult to convince them because they are talking from a particular point of view. Manas, I am not criticizing auditors, but you know, it is always and that should be the role, because you know, auditors should try to examine or get into the details as far as possible. Then only
absolutely correct, sir. Absolutely correct. Yes, sir.
Then only the veracity of these reports will remain. So, and auditing is one of the checks and balances of proper functioning of any account. A failure of auditors can lead to financial collapse. If
yes,
you know the case of Satyam Computers, where two of the auditors, Subrat, you don't have to inject everywhere. Please, wherever required, please come in. Otherwise, there is no point in just interrupting.
Sure, sir. Noted, sir.
In Satyam Computer case, two of the auditors were from PricewaterhouseCoopers, very famous firm, were involved in the fraud which was directed or managed by Ramalinga Raju. And they were suspended from their duties for some time by the SEBI and all that. So Satyam Computers, whatever fraud has been committed was mainly because of the oversight or actually lack of sight of the auditors. So Ramalinga Raju was responsible, no doubt, but these auditors allowed that because in that case it is told that there were in the balance sheet it was showing that there are certain deposits in the bank, but there were no deposits in the bank. That money has been transferred to Mitas, the other construction company. So there are so many reports like that. So this is where the auditor is very much required, and his role is very important. So what he should examine? Auditors have right to access at all time the books of accounts and vouchers of the company. And they can question anyone, because if suppose there is a transaction by the marketing department, by the materials department, by the project department, or even by the R&D department, any department, they can question, because every transaction they have the right to question. So they have to, and so they can get into anywhere, and they can ask whether that transaction is justified. They can ask for documents, they can ask for supporting documents, they can ask for the file to review and all that. The auditors can require from officers about information and seek explanation. They can even have, it's like, they will give a list of comments on the statement, and then you have to sit down with them to explain. They will cross-question you. It is like a court also in some times, you feel like. The list of matters on which auditors shall seek information and explanation includes proper security of loan and advances, transaction by book entries, sale of assets in securities in loss, loan and advances made shown as deposits, personal expenses charged to revenue account, cases of share allotted for cash. So all these they should check thoroughly and ask for explanation wherever required. Auditors in general meeting. The auditor shall attend any general meeting, AGM, or send his representative based on information from the company. The auditor must be given a reasonable opportunity to speak at the meeting on any part of the business which concerns him as the auditor. Notice of general meeting must be given before 21 days, either in writing or through electronic mode, to the auditor, specifying the place, date, day, time, etc. for the meeting. So in every AGM, the auditor has to be present, and he can keep his views wherever required. Next part is shareholders, equities, and the last agent we are talking of is the shareholders. Equity shareholders are the main stakeholder with voting rights in a company and receive dividend. Preference shareholders. Preference shareholders generally have no voting rights because of their preferred status. They receive fixed dividends generally larger than those paid to common stockholders, and their dividends are paid before common stockholders. Preferential share has been issued to people who are generally known to the promoter, or in they are very close to the promoters, and these people get preferential treatment because they have invested money before the IPO and all that can be possible, and they can get extra dividend, higher dividend, and that is paid before the other dividend is declared. The number of shareholders in a company depends on the type of company which they are opening. For a one-person company, one person is required, the proprietorship. For a private limited company, 2 directors or 2 persons are required. For a public limited company, a minimum of 7 persons are required. So a company which is listed, at least minimum 7 shareholders are required. But any private limited company, you can have 2 persons, 2 or more. Minimum is 2. Rights of shareholders. Participate in appointment of auditor and election of directors in AGM. That is one of the biggest right of shareholders in any corporate governance structure. In India, the shareholders also have the right to vote on the percentage of dividend declared. in UK and India, but in US, the board of directors decides on the percentage of dividend. Application to company law board to convene AGM, investigation of company affairs, etc. They have the rights. A particular percentage of shareholders can go to company law board to make the company convene an AGM if the company is failing or not doing. Investigation of a company affairs, they can complain against the company, and CLB, company law board, can get into investigate. Require the directors to convene extraordinary general meeting as I have 10% of the paid up capital. If 10% of the shareholders of 10% of the paid up capital, shareholders having share of 10%, they can convene, they can ask or request the directors to convene an extraordinary general meeting. Now tell me, AGM and EGM, so whether the auditor will be present in EGM or not?
Sorry, sir, can you please come again?
There are two general meetings. One is annual general meeting, another is extraordinary general meeting.
Yes, sir.
So in EGM, whether the auditor has to be present or not?
No, sir. EGM, no. The AGM
Present.
and audit budget, so AGM.
If you see the slide for auditors, it is said general meeting. It is not said annual general meeting only. So extraordinary general meeting, auditors also have to be present. So any general meeting, whether it is annual or extraordinary, the auditor has to be present. Participate in declaration of dividend. That is, in India, the shareholder has to vote. Demand a poll on any matter if they feel like. Petition to High Court for winding up the company, depending on the preference of the company. Participate in surplus assets of the company. When there is a winding up, they have the right to get money out of the surplus assets of the company. So this is there are some of the rights. I think we should stop at this today and take up in the next class. Or we can continue. I don't know.
Thank you, sir.
Anyone who any question you have, we can discuss for 2 minutes before the teacher comes in, the next teacher. I have not shared the first and 2 models with Rasmi Madam. I think I will share in a day or two, and she can circulate. I will talk to her, and then she can circulate.
Sir, will you share your idea about the dividend policy? How the dividend policy in India is working?
My idea on the dividend policy.
Yes, sir. Yes, sir. Can you
I
share
actually
your idea about the dividend policy in the function of Indian companies, in the context of Indian companies? It may be private or maybe PSU.
Actually, I'm not very sure what you are meaning, because I really do not know a policy of Government of India where which is laid down to declare a dividend. Dividend is declared by the way it is the prerogative of the board and the management to decide how much they want to pay. There has to be a rationale for doing that, but there is really no guideline, just that you have to declare this much of dividend to everyone. And so that is why there is a voting system where the board will propose or the management will propose that we will declare this year, this is our performance, we want to declare this much of dividend. And the shareholders have to approve that. The board, depending on the future mission and vision for the company, can decide to declare a particular amount of dividend. Now that, declaration of dividend takes into account many things. Now, if you are interested in expansion or acquisition or any expanding your business and all, you want to invest the profit which you have earned, then you may not give much dividend. But not giving dividend also is not a good thing, because that will reduce your impression as a good company in this secondary market. So declaring a healthy dividend is good for the shareholders, and your company's image remains. But while declaring dividend, you have to always be very objective. Objective in the sense it is not that you want to please the shareholder at the cost of the company. If the company requires certain investment for modification, modernization, for even you can say for safety, for environmental issues. So all that should be provision rather than just declaring dividend to please the shareholders. So that is what is my view. And
Sir,
Sir,
why is board is
my question
relies on
was about
outside director?
The PSUs are there to milk the government.
Why board is
Their intent to
please,
give dividend.
one
But
person should speak at a time.
sir, but the private companies like Tata, TCS, all the cash-rich company, they are not giving dividend. But the cash-rich companies like ITC are giving healthy dividend.
That is
So
what I said.
I'm asking,
It all depends on the board and the shareholder if they vote for certain things, but there is really no let down procedure. Why should somebody give and why should not somebody give? That is always a debatable question. Even if somebody pays you 100% dividend, you may not be happy. And even if somebody pays you 10% dividend, you will be happy, depending on the situation of that company. So, see, why TCS is not paying and why others are paying, that is a debatable question. We don't have time for that. But it is again the discussion of the board and the company management, how they think and how they perceive. Okay, Abhishek Kumar, you were saying something?
sir, why board relies on outside director?
It is not a question of relying on outside director. This has been made mandatory by the government to have outside directors so that the promoters or the directors who have direct interest should not hijack the company. There should be independent people to review the business of the company so that the other shareholders, the minority shareholders are protected. Okay, I think it is already time. I should leave. We'll meet tomorrow. I think we have 4 classes. Every next 4 days we have classes up to 4. So we'll meet tomorrow at the same time. Thank you.